Check, check. Can I be heard? Check. Check. Hello? Hello? This is embarrassing. Oh my dear good Lord. How about now? Am I here? Am I here? I've got to be here, right? Ah. I'm faint. What is going on? Okay. Okay. You know what? You know what can fix all of this? If I just say, it's January 9th, 2026, and this is the court gallery. Oh my goodness. Well, I don't know if you can hear me very well, but I'm going to talk us in anyway. I'm going to let you know that we are going directly to Bay County, Florida tonight, ladies and gentlemen. That is Panama City, and we're visiting with Judge Brantley Clark Jr., who has a very interesting case before him with a couple who went down to Florida to have a very nice time, and, well, one of them ended up with a jury trial instead. And that's where we are today. We are involved with a battery jury trial that involves illegal detainer, or I'm not sure. There's a whole lot of nuance going on here. Guy's not happy with the gal, beats her up. Good Samaritan steps in. Police get called. We've got body cam footage and everything to go along with it. And it all starts, ladies and gentlemen, right now.
We're on the record. It's January 9th. We're at the Bay County Courthouse, Annex, Courtroom A.
Somebody they can go to the lounge and check on the jury.
We have State of Florida versus Anthony Worley, case number 24 CF 3355. Mr. Worley is present in the courtroom. Mr. Meredith, Mr. White, and Walters are present in the courtroom. The assistant state attorneys. Do we have all the jurors should be coming in now? Anything we need to take up?
Is there anyone that can go to the judge's reception?
Judge, we've been going this week over the proposed jury instructions. I think we're pretty much in agreement. Mr. White added the lessers that I requested. They were all category 1. I think he added one category B that was a lesser. I don't object to that under the battery by strangulation. It's the felony that removes the domestic violence.
Okay.
So we're good on that. We've been going over the exhibits. I was provided this morning the photographs that White intends to enter into evidence, and the only, I don't know if you have the packet in front of you.
Madam Clerk does.
We gotta take this back. So
I see Colin Raiders coming in. So this is a great time for me to do the obligatory Colin pause that I have not done like 2 or 3 times. So I just want to say thank you very much, Colin crew and Colin alike. I really appreciate you. You're coming in at a really great time. We're just now starting the video. This is a Colin favorite, actually. This is Judge Hare himself, Judge Brantley Clark Jr. in Bay County, Florida. This is a jury trial for battery. They're actually about to start talking about some charges that have been added on last minute, that type of stuff. So it's kind of hard to hear at the very beginning right here when they're standing at their tables. So listen up, listen out, and the Colin pause is over.
I forgot to give it back. All right, yeah, I've got the there we go. I've got it with me.
State's Exhibit D 1 through 4. 2 and 3 just appear duplicative. One's a little bit closer, but they show the same thing. So I'm not sure. I'd ask the state to either pick 2 or 3 to use.
Mr. White?
If given a choice between the two, the state would choose Exhibit D3.
Okay.
But I don't see an issue with keeping both of them.
I don't either, Mr. Meredith. I mean, I know they're the same picture, just a little bit.
One's a little more zoomed in than the other, Your Honor.
But they're the same picture, so I don't see any prejudice from having one in or having both of them in.
At this time, considering your ruling, when the state moves to introduce it, would you consider that my objection to that, to one of those pictures to be timely made?
I'm gonna allow them both in over the objection of Mr. Meredith on behalf of Mr. Worley. That is an ongoing objection, and Mr. Meredith will not have to make that objection for the record. The objection is made now and is ongoing till the end of the trial.
The state has 3 videos and 1 body cam, and I think we're in agreement with that. I told Mr. White I wasn't going to require him to ask predicate questions because they are what they are, but the people that are familiar with those videos you need to testify. I don't think they should come in a vacuum.
Okay, Mr. White?
No objection, Your Honor. We have the witnesses to get it admitted.
Okay. Anything else?
At the appropriate time, I'd invoke the rule.
All right, and the rule would be invoked. So have you had a chance to talk to your witnesses about that?
They should almost be called in one at a time. I don't believe any of them are in the courtroom
Okay.
with us now.
If y'all just make sure,
They also should.
look back every once in a while, make sure you don't have a witness in here. I do, Deputy Dexter does a lot better job now, but we try to, if we see somebody that comes in later on, and we try to make sure they're not a witness, but sometimes they may slip in for us. Mr. Meredith, do you want the instruction about your client's right to remain silent?
If you could read paragraph 1, please. I think there's 2 paragraphs to that.
No, that's the final instruction. This is the preliminary instruction, just the right, the defendant has a right.
It's the same instruction. I don't know if they just put it in 1 paragraph or not.
It is, well, I can read it real quick, hold on.
I just noticed in previous trials that it seems to be both paragraphs together. And if it is one.
In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is the duty of a defendant to prove his innocence. And then the next sentence, it's not a paragraph, it's just in the same paragraph. From the exercise of the defendant's right to remain silent, a jury is not permitted to draw any inference of guilt. And the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever.
The second sentence, I would, if it's the choice between the whole thing,
No,
I want the whole thing, or just the first sentence.
I'll do what you tell me to do.
First sentence, please.
Just the first sentence. Now, if I start, you may want to call for stand up or something, and I'll remember. Okay. All right. Do we have a witness in the courtroom now? Okay. Very good. All right, Mr. Sullivan. Come get this.
Sure.
I got enough of a mess up here.
Thank you.
All right. Anything else?
So,
That's actually the exhibit, so I'm gonna give it back to you before I lose it. All right. So I'm ready, Deputy Dexter, whenever they're all here and ready to go, I'm ready to go. And we're going on the second amended information that was filed on Monday, is that correct?
Yes, Your Honor.
Very good.
23 to 39, can you let them know about time?
Are y'all cold, or is it just me?
extra.
It's just me?
Before we can begin, can we make sure that the monitor?
Sure. Just leave it like it is, Deputy Dexter. I'll get
It
me.
was said about just above 65, so that could explain why.
Some of us sweat more than others.
Somebody may have gotten here earlier on.
So just leave it, leave it at 65.
Okay.
I'll get me a cup of coffee. Maybe somebody will bring me one.
Seems to be working. Was there an audio issue yesterday?
We didn't use audio yesterday.
I don't know if it was operator area or,
No, yeah, it's HDMI. Oh, socket, I think they said.
Not going to dispute that.
doesn't matter now, does it?
Doesn't.
Thank you. Oh, did. And the jurors, if you'll remain standing when you get to your chair.
Yes, sir.
Everyone else can have a seat.
Right there, man, to that first one.
Let the record reflect that all the jurors are present in the courtroom, that all the jurors were on time this morning, and we're starting a little bit early, so maybe that's a sign of good things to come today. If you'll raise your right hand at this time to be sworn.
You do solemnly swear that you will well and truly try the issues between the state of Florida and the defendant whom you shall have in charge, and a true verdict rendered according to the law and the evidence, so help you God.
So help me God. You may have a seat. You'll get in your chair, and you can't get it adjusted like you like it. Deputy Dexter is an expert at it. Members of the jury, you have been selected and sworn as a jury to try the case of the state of Florida, Anthony Worley. This is a criminal case. Mr. Worley is charged with aggravated battery, domestic battery by strangulation, aggravated assault, deadly weapon, and false imprisonment. The definitions of the crimes charged will be explained to you later. You must decide this case based on the evidence presented and the law that I give you. Evidence consists of the sworn testimony of witnesses, exhibits admitted into evidence, and anything else that I tell you to consider as evidence. The state's charging document, which is called an information, is not evidence and is not to be considered by you as any proof of guilt. It is my responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusations beyond a reasonable doubt against Mr. Worley in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined. They do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you're not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits may be introduced as evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law applicable to the case. After the final instructions are given, you will retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you've heard all the evidence, the argument of the lawyers, and the instructions on the law that I give to you. Until that time, you should not discuss the case among yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. Jurors must decide the case without distraction and only on the evidence presented in the courtroom. Jurors must not conduct any investigation on their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case, the people and places involved in this case. You may not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. If you investigate, research, or make inquiries on your own, I have no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. This is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity, our judicial system promises. You are also not permitted to communicate about this case with anyone, including your spouse, family members, friends, neighbors, and even your fellow jurors. No communication includes no in-person, telephonic, or electronic communication, such as emailing, text messaging, posting information on a social media or a website, or any other form of communication. If you would like to take notes during the trial, you may do so. On the other hand, of course, you're not required to take notes if you do not want to. That will be left up to you individually. You have been provided with a notepad and a pen for use if you wish to take notes. Any notes that you take will be for your own personal use. However, You should not take them with you from the courtroom. During recesses, the bailiff will take possession of your notes and will return them to you when we reconvene. After you completed your deliberations, the bailiff will deliver your notes to me. They will be destroyed. No one will ever read your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence and should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. During the trial, the court may take recesses and you will be permitted to separate and go about your personal affairs. It is important to remember that the prohibition on communicating about this case applies during these recesses. Whether you're in the courthouse or elsewhere, if at any time you find yourself in a situation where others are discussing the case in your presence, leave that situation at once and immediately report the matter to the bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices, smartwatches, must be turned off while you're in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during recesses, but even then you may not use your cell phone or electronic device to find out any information about the case or to communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you're deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that will require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had the witness been permitted to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted to consume as little of your time as is necessary for a fair and orderly trial of the case. Mr. White, whenever you're ready.
Thank you, Your Honor. May it please the court, counsel. I asked you to stop. I begged you to stop. Those were the words that Ms. Connie Demang said on the night of October 12th of 2024, when a man that she loved, Anthony Worley, brutalized her. For his actions that night, he is charged with aggravated battery, domestic battery by strangulation, aggravated assault, and false imprisonment. You will hear from Ms. Connie as she explains that they were down here searching for a place to live with the intention of getting married. They were staying at the Lagoon Motel, and the Lagoon Motel is near Captain Anderson's. Right across from that motel is a pontoon rental business. Ms. Connie was at that business when some men catcalled her. And Mr. Worley, who had been drinking that day, took offense to that. And he went into a jealous rage, and they got into an argument. Connie decided that she was going to go back to their hotel room, that she was going to grab her keys, and she was going back home to Georgia. Mr. Worley followed her into the hotel room, grabbed her by her hair, and threw her to the ground. And that is when chaos ensued. He kicked her, he punched her, he threw her around the room like a rag doll. He threw her on the bed, he threw her off the bed onto the floor. At one point, you will hear how he was sitting straddled across her torso, across her body, the midsection of her body, and had a pillow held over her face and was strangling her. She tried to get away, and he refused. At one point, he had a long handgun in his hand, and he was waving it around the room and said, "I have one bullet for you and one bullet for me." Eventually, she was able to get out of that room, and Mr. Worley followed her outside of the room and tried to drag her back into it. And you will hear from the testimony of Mr. Eric Stoll, who was the Good Samaritan that day and saw them struggling and intervened and helped Miss Connie escape from the defendant. You'll be able to hear the defendant say, "She's trying to kill me. She's crazy," as he's dragging her back into their hotel room. You will also hear the testimony from Deputy Jake Patterson of the Bay County Sheriff's Office, who arrived on scene and saw the two of them. You will hear him explain how she was beaten to a pulp. Her cheeks were swollen. She had a huge swollen abrasion on her forehead. She had blood throughout her hair. And the only injuries to Mr. Worley were bloody knuckles. Deputy Patterson searched that hotel room and found two firearms, both of them being handguns, one of them being longer than the other, and the longer one was loaded with .44 Magnum ammunition. Finally, you will hear from Ms. Tammy Dean, who helps to manage and run the Lagoon Motel. And Ms. Dean will explain how she had cameras set up outside the hotel, and she detected activity that night, that she heard screams coming through the walls of the hotel room, and that she had her husband contact law enforcement. Ms. Dean continued to monitor those cameras, and that's where Mr. Worley dragging Ms. Connie back into the hotel room can be seen on camera. And you can see Mr. Stoll intervening to break them up. You will see pictures of Ms. Connie's injuries, both on the night of the incident and a couple of days later. You will see the firearms that were recovered from the hotel room, and you will see a picture of the bloody pillowcase and the pillow that he used to strangle her. And that pillow was found by Miss Dean, the hotel manager, the day later when she came to clean up the hotel, hidden behind the refrigerator. Once you've heard all the evidence, the only just verdict in this case will be guilty as charged. Thank you.
Eric?
Please, the court, counsel. Mr. Worley's waited 14 months for today. So I ask that you listen carefully to what you actually hear in terms of testimony and how it matches up with what somebody may have said earlier about what they had seen or heard, what they'd witnessed or was said to them about the injuries and the treatment. Now, Tony Worley was married most of his life. After his wife died, he had some jewelry that he put up for sale. That's how he met Miss Connie Demang. She came and she bought a couple pieces of the jewelry. Mr. Worley may have given her a few pieces, and they began a relationship. Now, this happened in the summer of 2024. A little bit later, Tony sold his house, and his mother lived down here in Panama City. So he brought Connie with the proceeds from selling that house down to Panama City with the purpose of marrying her. Bought her a ring, paid for everything she had, paid for a car. He was willing to start a life with Connie. But when they got down here, they didn't stay with Tony's mom. They got rentals as they were looking for a place to stay long term. And they would go fishing, and they go drinking. They go drinking, and they go fishing. They checked into the Lagoon Motel, and they'd been there about 4 days when October 12th happened. Now, on that day, they were both drinking. And I suspect you're going to hear the amount of alcohol that Ms. Demang had consumed. Something happened in that room. And another tenant hears it and he intervenes. The owner has that video, so it shows you what happens outside the room, but you don't get a chance to see what happens inside the room. Who started it? What injuries each one sustained. Now, he's been charged with 4 very serious charges. The state is not going to be able to prove those main charges. And in fact, some of the charges are not supported at all by the evidence. So at the end of the presentation of the evidence, get a chance to come up here and tell you what the evidence does show and what charges could be supported. And then you will make your decision. Mr. Worley is not guilty of what he's charged with.
Mr. White, may call your first witness.
Your Honor, the state calls Connie Demang.
Get you to come here and stand by this chair, and the clerk's going to swear you in.
Would you raise your right hand, please? You do solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth so help you God.
Yes, ma'am.
All right, ma'am, if you have a seat,
Yes, sir.
speaking to the microphone, Mr. White, you may inquire whenever you're ready.
Thank you, Your Honor. Good morning, ma'am. Can you please introduce yourself to the jury?
My name is Connie Demang.
And how old are you?
I am 54.
And where do you live?
I live in Noonan, Georgia.
Are you a convicted felon?
I am.
How many times have you been convicted of a felony?
1 time.
Have you ever been convicted of a crime of dishonesty?
Yes, sir.
And how many times?
1 time.
And about how old were you when that happened?
I'm like,
Sustained.
Do you know what year you were convicted?
Objection.
Sustained.
How did you meet Anthony Worley?
we have a mutual friend, and I was a big time fisher. And I had been wanting to fish in his pond for a long time. And she said she knew him and took me over there to fish.
Okay.
And I ended up just staying.
Do you know approximately when that would have been?
About a year and a half ago, maybe.
How long after meeting Mr. Worley was it before you started a relationship?
A day, couple days. Immediately.
And were y'all together in Georgia or down here?
Both.
Both. What brought you to Bay County?
His mom got sick.
And when did you get down here?
I'm thinking maybe around August,
What year?
August 2024.
Were you in Panama City on the night, or were you in Bay County on the night of October 12th of 2024?
I was.
And where were you staying?
I was currently at the Laguna Inn Motel.
Why were y'all staying there?
Just where we chose to stay to watch the boats.
Okay. And what was the status of your relationship at that time?
We were getting married.
Okay. Did you get into an argument that day?
Yes, sir.
Can you tell us about that?
We had just been arguing all day, basically. I was down at the bay, at the dock fishing, and some guys had been talking.
What sorts of things were they saying?
Objection, hearsay.
What?
Were you catcalled?
Yes, sir.
What was Mr. Worley's reaction to that?
He was telling me that I was ugly and nobody wanted me, and I told him that's not what the guys said outside. So, coming up to the room, he seen some guys out there. So he started an argument with them, which was the wrong people. And it escalated from there.
What did you decide to do at that point?
I said I was going back to get my keys and go back to Georgia.
How did he react to that?
He didn't like that.
Did you go back to the hotel room?
I did.
Did he follow you?
He did.
What happened once you got into the room?
He jerked me to the floor.
Once you were on the ground, what was he doing?
Punching me in my face.
Did he do anything else to you?
He kicked me a few times.
Yeah. Did you stay in that position on the floor?
No, sir.
What happened?
He jerked me up, threw me back on the bed.
What did he do to you when you were on the bed?
Slapped me a few times, and then he jerked me back up and threw me back on the floor. That's when he got on me and hit me some more, kicked me a few times. At that point, he got me back off of the floor, and that's when he had a gun.
Do you remember anything about that gun?
I remember it was long, kind of.
Did he say anything while he had the gun?
Yes.
What did he say?
He said, "Bitch, I've got one bullet for you and one bullet for me."
And what was he doing with the gun at the time?
He was just waving it around like crazy. Yeah.
Did he ever aim it at you?
He was like, "I've got one for you and one for me," like that.
Okay. Was the barrel of the gun ever pointed in your direction?
Yes, sir.
Okay. What was your reaction to that?
I was hysterical and begging for my life. I was bleeding really bad. I knew I had to get out.
Where were you bleeding from?
I didn't really know. My face, my head, it was just everywhere. I knew I had to have help.
What did you do then?
I was screaming.
Do you remember screaming for help?
Yes, sir.
At some point, did he do something with the pillow?
Yes, sir. He put it over my face and told me to stop screaming.
Can you tell us about how that, like, when that happened?
After he threw me back on the floor, he sat on me and he put that gun back in the pillow and laid it there. And then he threw me on the floor and then he got on me, the pillow, and I think that's what busted my face, his gun in the pillow.
Were you able to breathe normally?
No, sir. I thought I was gonna die.
How did it impact your breathing?
I couldn't breathe. I was gasping for air.
Had you been drinking that day?
Yes, sir.
What were you drinking?
It started out with beer and then it ended up with Patron.
Were you drinking Patron?
I did drink some Patron.
Do you remember how intoxicated you were?
I don't know how drunk I was, but I was drinking.
But you have memories of what happened?
I have, yes.
Okay. So you were aware of what was going on?
Yes, sir, to a certain extent. I think I blacked out somewhere.
And was that before or after the fight?
During the fight, pretty much. Towards the end.
At that point, had you been hit?
Yes, sir.
Had you had injuries to your face?
Yes, sir. I didn't know to what extent, but yes.
Okay. Had you seen Mr. Worley drinking that day?
Yes, sir.
What was he drinking?
Beer and Patron.
Did he drink more or less than you?
More.
Do you remember getting out of that hotel room?
No, sir.
Did you have any broken bones from this incident?
Yes, sir.
Was your nose broken?
Yes, sir.
Was your eye bone broken?
Yes, sir.
Your Honor, may I approach?
May I approach?
Your Honor, I'm approaching with what has been pre-marked as State's Exhibit A1 through 3.
Okay.
Do you recognize these pictures?
Yes, sir.
What are they?
Pictures my sister took days after the accident.
Do you know how many days it was?
Maybe 2.
Okay.
Maybe 3. Maybe 2. Yeah, 2 days.
Are these a true and accurate reflection of your injuries?
Yes, sir.
Your Honor, the state seeks to admit into evidence State's Exhibits 1 through 3, A1 through 3.
States A1 through 3 will be accepted evidence. You may publish whenever you're ready.
Thank you, Your Honor. At some point later that night, did you go to the hospital?
Yes, sir.
Okay. And do you know when you were released?
The next day,
And is that when you went to your sister's house?
I did.
And that's when these pictures were taken?
2 days after that.
Okay.
I left on the 13th, so that would put it at 14th, on the 15th when she took them.
Okay. And is the person that did this to you in the courtroom with us?
Yes, sir.
Can you please identify him by pointing to where he's sitting and describing what he's wearing?
He's in the blue shirt in the front.
Your Honor, may the record reflect that the witness has identified the defendant.
Record will so reflect.
There are no further questions for this witness.
Meredith?
Ms. Demang, we met several months ago when I took your deposition. Do you remember that?
Yes, sir.
Now, my understanding is that you met Tony Worley there in Moreland, Georgia, on his property.
Yes, sir.
You met through a friend.
Yes, sir.
Now, his wife had passed away just before that.
A
Is that
couple
right?
years before that. Yes, sir.
Now, didn't he share with you some of her jewelry?
No, sir.
You didn't go over there to look at some of his jewelry?
His mom's jewelry. Yes.
His mom's jewelry?
Yes,
Okay.
sir.
Okay, so you did look at some jewelry and get some of that?
I did not get none of it. No, sir.
But Tony liked fishing too, didn't
Yes, sir.
he? That's kind of a part of your relationship was your love of fishing.
Yes, sir.
And your relationship started pretty quickly after you just met him.
Yes, sir.
And he basically took care of you, didn't
We took care of each other. Yes.
he? He was paying for all your bills, right?
I had my own job at first.
He bought you a car.
My car tore. Yes, he bought me a car.
And he paid your rent, paid for your food, paid for everything, I think is what you said.
Yes.
Now, his mom was living down here in Panama City, and that's why you guys came down here.
Yes, sir.
And you think that was August or September, maybe?
I'm not sure. We were back and forth all the time.
He sold his house there in Georgia to fund your move to Florida, right?
Yes, sir. His move. Yes.
But you were staying with him, right?
Yes, sir.
You were going to get married.
Yes, sir.
Now, did you ask him or did he ask you?
He asked me.
Got you a ring?
He did.
And this happened in October, October 12th, 2024.
Yes, sir.
And you were still planning to marry him in November of that year, weren't you?
Yes, sir.
He was still taking care of all your bills, right?
Yes, sir. I was living with him.
And then he stopped paying for your bills, right?
No, sir.
Are you suggesting he's still paying for your bills today?
Not today. No.
He hadn't paid for your bills in quite some time,
Since he went to jail.
over a year.
Yes, sir.
Now, on October 12th, you admitted to Mr. White that you were drinking.
Yes, sir.
Were you drunk?
I'm not qualified to say that.
Okay.
I don't know.
You did go to the hospital later on, right?
I did.
And they ran a series of tests on you.
They did.
In fact, they took blood.
Yes, sir.
Would you be surprised that your blood alcohol was 0.236?
No, sir.
And would you be surprised that the diagnosis, or at least part of it, was acute alcohol intoxication?
Yes, sir.
Yeah. Both yours and Tony's drinking was out of control at that time, wasn't it?
For that day, yes.
Yeah. You knew Tony had guns because you'd been with him for about 6 months, right?
Yes, sir.
So before you were in that hotel room that day, you knew he had pistols.
In the truck, yes.
So you knew that he owned them and that he had brought them with him to Florida.
Yes, sir. We had a conversation about that because I didn't know how the permits worked going back and forth.
Because you were a convicted felon?
No, sir, because I didn't, well, that was not what I was talking about. I was talking about him getting in trouble, carrying it in Florida with a Georgia license. I didn't know how that worked.
Now, you claim he put the pillowcase over your face.
Yes, sir.
Now, the gun was in that pillowcase when he did that, right?
Yes, sir.
Okay. You think that's what caused some of your injuries?
Yes, sir.
Now, he didn't actually pull it out at you, did he?
Yes,
He pointed it at you?
he did.
Do you remember talking to Deputy Patterson at the hospital when you were there getting treatment?
Not really. I was on fentanyl then.
And Halidol as well, right?
Yes, several things.
You don't remember giving him a statement at all?
I really don't.
You don't remember telling him that you don't remember much of anything?
Sir.
And you don't remember if he asked you specifically if he pointed the gun at you and you said no?
I didn't want him in trouble.
Now, these pictures, the bruises are pretty distinct, right? But those pictures were taken 2 or 3 days after, right?
Sure.
And you would agree with me that bruises get worse and more discolored over time before they heal, wouldn't you?
I'm not qualified to say that.
But those pictures were taken several days later.
2 days later, yes.
Now, did you black out when the pillow was over you, or you're not sure?
No, I did not black out then.
Okay. Because then you were actually gasping for air,
Yes,
right?
sir.
Okay. So you were able to get some air in, right?
Obviously.
It wasn't impeded to the point that your total airflow was restricted, was
I
it?
was praying to God at that point.
But you could still gasp, you could still yell, and you still yelled for help.
I wasn't able to yell, but I tried.
Now, when you got up, you were able to go out the door. But you don't remember that, do you?
I do not remember going out the door.
Okay. So I guess video evidence of that would be better, right? But you don't remember Tony pushing you into a corner or trying to throw you into the bathroom or anything like that to keep you in any of the rooms, do you?
I remember I took off running for the door from the bed. And that's when he wouldn't let me go out the door. I tried. Because I knew I had to have help. There was so much blood everywhere.
But you don't remember going out the door?
I do not.
I don't have any other questions.
What? Excuse me, Your Honor. When the pillow was on your face, you were having a hard time breathing, weren't you?
Yes, sir.
You weren't breathing normally?
No, sir.
You told Deputy Patterson that you did not want to give a statement, right?
Yes, sir.
You told him that he did not aim the gun at you?
Yes, sir.
Why did you tell him that?
Because I love Tony and I didn't want to get him in trouble. So I didn't want to I didn't want him locked up.
Do you still have feelings for Tony?
I do.
Does him buying you and paying for your luxuries and ease of life give him the right to do what he did to you?
No, sir.
No further questions, Your Honor.
Any other questions?
Yes, sir.
If Deputy Patterson asked you to swear to tell the truth and you gave him a different statement, that would be like lying, wouldn't it?
I was intoxicated. And I told them I did not want to give statements. I didn't want them taking pictures. I told them all that.
If you did, you would have told him the truth, right?
Yes, sir.
Any other questions for this witness?
No, Your Honor.
Can she be excused?
No, Your Honor.
Ma'am, you're still under the rule. You'll need to leave the courtroom. However, you may be subject to recall, okay?
Yes, sir.
White, you can call your next witness.
Your Honor, the state calls Mr. Eric Stoll.
Please. Come up here, stay by the chair, and the clerk's going to swear you.
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth to help you God?
Yes, I do.
Thank
All
you.
right, sir. All right, sir, if you'll have a seat, move the microphone where you can speak directly into it. And Mr. White, you may inquire whenever you're ready.
Thank you, Your Honor. Good morning, sir. Can you please introduce yourself to the jury?
My name is Eric Stoll.
And how old are you?
I'm 68.
What do you do for a living?
I'm retired.
Were you staying at the Lagoon Motel on October 12th of 2024?
Yes, I was.
On that day, did you hear any signs of an altercation?
Yes, I did.
What did you hear?
First, I heard 3 thuds on the wall. Maybe separated by 20 seconds, I guess, but it was sound like something hit the wall. And then I thought it might have been the person next to me. But then when I heard it twice more, I knew it wasn't the guy next to me.
Did you find out where that sound was coming from?
Well, after the thuds, I kind of knew that there was trouble, and I heard a scream. My door was shut, and I wasn't sure if it was on the I was watching a football game, and I wasn't sure if that scream was just part of the crowd noise. But then I heard another scream, and then I knew that it was coming from outside, and I called 911.
At some point, did you leave your room?
Yes, the screams got louder, which I took as being the door was now open to the apartment where the trouble was going on. So I opened my door and heard a woman screaming, he's trying to kill me.
Did you see a man and a woman?
Yes.
What were they doing?
Well, when I first saw him, he was trying to pull her back in the room. He was behind her and had her not around the neck, but around the chest, trying to pull her back in the room. And there was a captain's chair there, which is a very heavy chair, like 200 pounds. And she was trying to hold on to the chair to keep from getting pulled back in the room.
Did you intervene?
Yeah, I ran down there, and as soon as I got there, they fell into the room backwards. There's like a 3 or 4 inch step going into the room, and before I could even touch anybody, they fell back into the room, him on his back and her on top of him. But as soon as he hit the ground, she broke free.
Did you get between them?
Yeah, she ran out of the room, and I just said, stop, just stop.
Who are you saying that to?
To the man in the room.
Did you tell the woman to go anywhere?
Yeah, she was hysterical. I mean, I told her to go down to my room just to get away, put some distance in between the two of them.
And did you see any injuries on her?
Yes. Face, I believe one was on the eye, and she was bleeding from the back of the head.
Did you see any injuries on him?
No. But I didn't really look. I didn't see any injuries, but I didn't look.
Did either one of them seem intoxicated?
Yes. The guy did.
What kind of signs was he showing?
Slurring. I could smell alcohol, but I don't know if that was coming from him or her, but I did smell alcohol.
Did you stay there until the police arrived?
Yes.
There are no further questions for this witness.
Meredith?
Mr. Stoll, it's good to see you again. I think I talked to you back in September.
Yes.
Now, before this incident, you had met Mr. Worley because y'all were sort of neighbors there at the motel, right?
I had seen him, and the only time I talked to him, he had a circuit pop in his room, and he asked me where the circuit box was. That was the only time I ever talked to him or her.
In that interaction, I think you described him as seeming very nice.
I don't remember saying very nice, but I didn't see any problem, or I didn't really interact with him enough to make but there was, I didn't see any reason for concern. He seemed normal person.
Okay. You gave a statement to one of the deputies that showed up there on the scene, right?
Yes.
Okay, and you told him about that initial interaction about the circuit breaker or whatever?
I think so. I really can't remember.
Well, on October 12th, you heard this thumping, and you initially thought it was coming from the TV from the football game.
Mm-hmm.
You couldn't see what was happening in Mr. Worley and Miss Demang's room.
No, I couldn't.
You don't know who started the fight or what started it, do you?
No, I don't.
Now, when the lady does come out of the door, you intervene.
Mm-hmm.
All right. And he has his, I think you described it, you used your left arm around her chest.
Mm-hmm.
Okay. Didn't have his hand around her neck or anything like that.
No.
Wasn't pulling on her hair or anything like that.
No.
Now, did you push Mr. Worley back?
No. He tripped.
Do you remember giving that statement to the Deputy Moliturk?
No.
So you don't remember what you told him at the time?
No, I don't remember the exact. No, I don't remember the exact statement that I said.
Right. Your interaction with Mr. Worley and Miss Demang there at the door was pretty quick, right?
Very quick.
Okay. And she was able to get up and get away.
Yeah, she as soon as they hit the ground, she, I guess, from the shock, she was able to run out the door.
So Mr. Worley wasn't able to keep her in the room.
No.
Now, they were both drunk, weren't they?
I really, I have no way of knowing.
She was kind of yelling and screaming some.
Mm-hmm.
Mr. Worley was talking excitedly as well, wasn't he?
Yes.
Okay. And you told Mr. White that Miss Demang said he's trying to kill me. Wasn't it Mr. Worley that said she's trying to kill me very excitedly?
Yeah, when I told him to stop, he was laying on the ground and I wasn't holding him down, but I just had my hand on his chest and I said, stop, stop. And he goes, she's trying to kill me.
You never saw any weapons?
No,
Never saw any firearms?
no.
I don't have any other questions.
What?
No further questions, Your Honor.
Can the witness be excused?
Yes, Your Honor.
No
Sir,
objection.
Sir, you may go about your day.
Thank you.
Why, you can call your next witness.
Your Honor, the state calls Deputy Jake Patterson.
Right, please. Come stand by the chair and the clerk's going to swear you.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth to help you God? Thank you.
Good morning, sir. Can you please state your name, or can you please introduce yourself to the jury?
Yes, sir. Deputy Jake Patterson.
And what do you do for a living?
I'm a deputy sheriff at the Bay County Sheriff's Office.
How long have you worked there?
Been just over 2.5 years at the Bay County Sheriff's Office.
Do you have any prior law enforcement experience?
Just under 2 years at Franklin County.
What sort of training and experience does it take to become a law enforcement officer?
Approximately 10 months in the academy to become a Florida law enforcement officer.
Did you receive any type of specialized training in domestic violence?
The domestic violence courses we received in the academy, but nothing post-academy.
Okay. Had you responded to a domestic violence incident prior to October 12th of 2024?
Yes, sir.
At this point, around how many domestic violence cases have you reported to?
Approximately 500-ish.
Were you working on the night of October 12th of 2024?
Yes, sir.
All right. Were you ever dispatched to the Lagoon Motel?
I was dispatched to the Lagoon Motel twice that night.
May we approach?
Approach.
Did you respond to a domestic situation at the Lagoon Motel?
I did.
All right. What did you see when you arrived on scene?
When I arrived on scene, initially there was a bystander stating he had a gun. I then saw the victim sitting in a chair on the north side of the parking lot, like on the sidewalk. Approached her, asked her what happened. She was explaining the situation to me. When I turned my flashlight on to be able to see her, saw her face had severe bruising, lacerations on her forehead, and her hair was matted with blood. She was also crying.
At that point, did you confront Mr. Worley?
At that point, I turned to look towards the room they were in, room 8. I noticed the door had opened. Could not see the door. I could see the top of Mr. Worley's head. There was a vehicle in between us. I drew my service weapon based on the statements made to me about him possibly being in possession of a firearm.
Judge, I'd ask that that be disregarded and stricken from the record. That's not responsive to the question and subject to a previous objection.
Sustained. Just answer the question and don't answer in the narrative form. Just answer the question and wait for the next question. Okay?
Yes, sir.
Mr. White, may continue.
Did you confront Mr. Worley?
I did.
Did you place him under arrest?
I did.
Did you take him to the back of your patrol car?
The front passenger fender first.
Did he make any statements to you?
He didn't.
Right. And these were not in response to anything that you asked him?
No, sir.
What statements did he make?
He had stated that he was attacked.
Okay. At that point, had you noticed any injuries on him?
No, sir. Other than knuckles being busted.
And where on the knuckles were those injuries?
They were peaks of the knuckles.
And based on your training and experience, what do injuries to the peaks of the knuckles indicate?
Objection calls for speculation and an opinion.
The Injuries to the peaks of the knuckles indicate offensive injuries, striking injuries from my experience.
Okay. Your Honor, may I approach?
May approach. I'll give it after you introduce it, okay?
Your Honor, the state is approaching with what has been marked as State's Exhibit B. All right. At this point, Your Honor, the state seeks to have admitted into evidence State's Exhibit B, which is the body cam of Deputy Jake Patterson.
Mr. Meredith?
No objection is no.
All right. I'm going to accept State's Exhibit B into evidence. You may publish whenever you're ready. You're getting ready to publish it at this time. Is that correct?
Yes, Your Honor.
Members of the jury, you're about to view a video recording. The court instructs you that the recording has been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recording has been edited should not concern you in any way and must not impact the way you view and consider this evidence. You may publish whenever you're ready.
Thank you, Your Honor.
Yes! Yes!
With the gun?
God, yes!
Deputy Patterson. Can you see the injuries as you saw them that night on her face?
Yes.
Can you describe those injuries for us?
Laceration to the forehead above the right eye, bruising on the right cheek below the right eye, and matting blood in the hair. Okay. 4, 5, 6 back.
Show me your hands now! Show me your hands! Get down! On the ground! Want to go point? Get down! On the ground, all the way! On the fucking ground! Hands on your back!
Should take me, sir. Should take me. You're a prostitute. Prostitute.
Get up.
Hey!
Get the fuck up.
Hey, look!
Stop.
Got that prostitute don't tell me about guys right where the room's off.
Four, 5, 6 by 1 to 10.
Dollars for women.
Sorry, I told you to stop.
Connie. For real.
I told you to stop.
Oh my God. Oh my God, man. For real.
I told you to stop. Oh, you kidding me? Where's the faithful life?
Does that video accurately reflect your initial encounter on scene?
Yes, sir.
What was Mr. Worley's condition like when you first encountered him?
Intoxicated.
Intoxicated? What signs of impairment did you see?
Smell the odor of alcohol on his breath, as well as slurring his speech and instability on his feet.
Was he belligerent?
Yes. From the body camera footage, he was name calling.
Did his condition change after you placed him under arrest?
Yes.
How did it change?
So once placed in the back of the patrol car, began yelling, and then we had a medical related issue.
Yeah. Did you have to call EMS?
I did.
After that, did you search the hotel room?
We did.
What did you find in the hotel room?
We located 2 firearms, one of which was a .44 Magnum, which was loaded. Both firearms were inside of a pillowcase on the bed.
May I approach?
May I approach?
I'm approaching with what have been pre-marked as State's Exhibits C1 through 3. Any objection? At this point, Your Honor, the state seeks to have Exhibits C1 through 3 admitted into evidence as A1, the Ruger Super Blackhawk 44 Magnum, A2, the 44 Magnum ammunition, and not A, C2, and C3, the 32 caliber Harrington and Richardson revolver.
Mr. Meredith, you indicated there's no objection. Is that correct?
That's correct.
State's Exhibit C1 through 3 will be accepted into evidence. You may publish whenever you're ready.
Thank you, Your Honor. Permission to publish.
You may publish.
All right. Can you go ahead and open C1? Can you take it out of the box and present it to the jury? And what is that firearm?
This is a Ruger Super Blackhawk 44 Magnum revolver.
Do you notice anything about that revolver?
It's quite large.
And more specifically, in what dimension is it large?
The barrel length is long.
So it is long.
It would be considered a long handgun.
And what condition was that firearm in when you found it?
It was loaded.
And can you present State's Exhibit? You can go ahead and put that and place that back in the box. And can you present State's Exhibit C2? Where were those located when you found them?
These were located inside of the Ruger Blackhawk.
Okay. And can you present C3 to the jury? Your Honor, may I approach?
You may approach.
I'm approaching with what has been marked as State's Exhibit D 1 through 4. Any objection?
Except as otherwise noted, no objection.
At this point, Your Honor, the state would seek to have admitted into evidence State's Exhibits D 1 through 4.
State's Exhibits D1 through 4 will be accepted into evidence. You may publish whenever you're ready.
Thank you, Your Honor. Can you tell us what this is?
This is the interior of room 8 at the Lagoon Motel.
Okay. And can you present that to the jury? Can you describe what this is?
It is a blood stain on the rug and on the floor in the hotel room.
Does that rug match the rug that is found in the picture showing the entire room?
Yes, sir.
All right. Can you tell us what this is?
That is another photograph of the blood stain on the rug as well as the floor of the motel room.
That's the jury. And can you tell us what this is?
That is a blood smear on the door frame entering the room.
And do these pictures accurately depict the condition that you found the room in?
Yes, sir.
After you searched the hotel room, what did you do?
After the initial search, I followed EMS to the hospital, escorted EMS to the hospital.
Is that when you attempted to take statements from Miss Connie?
Inside the hospital, yes, sir.
And was Mr. Worley also at that hospital?
Yes, sir.
So were they transported to the same hospital?
They were transported to the same hospital.
Do you know why they were transported to the same hospital?
That would be a paramedic or emergency medical question.
What hospital were they transported to?
Ascension Sacred Heart Bay Med.
And what type of hospital is Ascension Sacred Heart?
It is the trauma center for Bay County. They're most well equipped to treat trauma-related injuries.
Okay. Did you end up having another altercation with Mr. Worley?
I did.
Can you tell us about that?
Objection.
You want to approach?
Relevance.
Your Honor, this is going to be testimony related to another belligerent incident, which was
Let's approach.
You can answer the question.
Yes, I did have another altercation with Mr. Worley at the hospital. He attempted to leave the hospital, and the altercation was an attempt to keep him within the hospital until he's cleared by medical.
When you told him to go back into the hospital, did he listen?
There was no change when I ordered him to stop.
Okay. Did he act belligerently towards you?
He was pulling away, saying no, stuff like that.
Okay. You resist your attempts to get him back into the hospital?
He
Objection.
I'm overrule the objection.
He did resist, but it was by pulling away. It was not with violence.
Okay. Right, no further questions, Your Honor.
Meredith?
There were 4 pictures. And 2 and 3 are the same picture, just one's up close, right?
Yes, sir.
It's not 2 separate listings.
No, sir.
Now, Mr. Worley was coming out of his room and he got down on the ground as you ordered him to.
Yes.
Correct? Okay. Put his hands behind his back when you ordered him to.
Yes.
All right. You were being a little bit aggressive, and I understand why, but I mean, you were taking control of the situation, right?
Yes.
Okay. And I believe your testimony was that he said he was attacked by Connie.
Yes, sir.
Now, you didn't find any weapons on him, did you?
Not on his person.
And the firearms were inside of a pillowcase.
On the bed.
One was loaded and one was not.
Correct.
Now, if there was any issue with Mr. Worley being in possession of those weapons, you would have charged him with that too, wouldn't you?
It's not a felony to be in possession of weapons unless you're a convicted felon.
Thank you. Now, on the scene, you didn't notice any injuries other than those knuckle scrapes?
To the knuckles.
But Mr. Worley was taken to the hospital.
Yes, he was.
It was the trauma hospital, right?
Yes, sir.
And I believe in your report, it's because EMS notified you that it was status red.
Yes.
And status red means there's immediate life-threatening injuries, but survival is likely if treated equally or treated quickly.
Correct.
Okay, so that's what a status red is.
That is what a status red is.
And that's what was called on Mr. Worley. Now, at the hospital, Mr. Worley underwent a CT scan, didn't
I'm not sure.
he?
Do not recall.
Didn't you learn that he had a bump or a contusion on the back of his head?
Yes.
And Is it fair to say hospital staff was having problems with both of them?
They were having problems with both of them.
Thank you. Now, you, at one point, tried to take a statement from Ms. Demang.
Yes,
You recorded it, and it was also body cam, right?
yes,
And at the time, she had been given fentanyl and Halidol to calm her down, right?
yes,
She told you she didn't remember much, right?
correct.
She said that repeatedly, over and over and over again, right? In fact, you had to lead her in some of the questions about what happened, didn't you?
I asked her what happened.
You asked her specifically if Mr. Worley ever pointed the firearm at her, did you not?
I did.
And her answer was no. Correct?
Correct.
Don't have any other questions.
Why didn't you redirect?
Yes, Your Honor. What symptoms did you see before calling EMS for Mr. Worley?
Mr. Worley had went unresponsive. He was initially yelling that he had arm pain, and then he went unresponsive while in custody.
Okay.
Did you see any sign of physical injuries to him?
Not on scene, other than his knuckles.
Okay. Based on your training and experience, what types of injuries are common when a woman has battered a man?
Scratches.
Objection.
I'm gonna sustain the objection.
Okay. He had no physical injuries other than what was on his hands?
On his knuckles. Those were the only ones I saw on scene.
All right. No further questions.
Any other questions?
No, Your Honor.
Witness be excused.
Yes, Your Honor.
No objection.
Sir, you may go about your day.
Put the ammo back in the bag.
Yes. Is this the appropriate time to take our morning break, Mr. White?
Doug, fine, Your Honor.
Sounds good.
All right, we're gonna take a 15-minute break. We'll start back at 20:11.
Go around.
Leave your notepads in the courtroom. Do not discuss the case among yourselves or with anyone else. Don't check any media sources or use your electronic devices to find out any more that about the case you know right now. You'll leave your notepads in the courtroom, follow the bailiff out in the back. I'm gonna ask everyone else to remain in the courtroom until the jurors have left the courtroom. We're in recess. Jurors can have a seat when you get to your chair. Everyone else can have a seat. Mr. White, for the record, everyone's present. You can call your next witness.
Your Honor, the state calls Ms. Tammy Demang.
Right, please, man. The Woods, come up here, stand by the chair, and the clerk is going to swear you in, okay?
You raise your right hand, please. You do solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth to help you God.
If you'll have a seat and speak into the microphone, Mr. White, you may inquire whenever you're ready.
Thank you, Your Honor. Good morning, ma'am. Can you please introduce yourself to the jury?
I'm Tammy Dean.
And what do you do for a living?
My husband and I own the Lagoon Motel and we manage it.
And where is that located?
5917 North Lagoon.
Is that in Bay County?
Yes.
Were you managing the Lagoon Motel on the night of October 12th of 2025?
Yes.
At that point, did you know who Anthony Worley and Connie Demang were?
Yes.
How did you know them?
They rented a room at the motel from us a few days prior to that night.
And how long had they been staying in the hotel the night of this incident?
I'm not exactly sure, probably 3-4 days. They had paid rent for a week at that time.
Okay. Do you have cameras set up around your hotel?
Yes.
At some point, did you detect, or can you describe for us how those cameras work?
They're picked up based on motion and they pick up clips, everything that goes on at the motel. They're saved to a home base inside the office, and then I can view any camera at any time, or I can go back and look at any clip from the camera.
Were you monitoring the cameras that night?
I do. We do that, or my husband and I both do that periodically just to make sure nothing's going on at the motel, because we're not there 24/7. So we watch the cameras just periodically. So yes, that night I was looking at them.
At some point, did you hear some unusual activity?
Yes, while I was viewing one of the cameras, I could hear someone screaming in one of the rooms.
How did you respond to that?
I told my husband to call 911 while I was watching the camera.
And you continued to watch the cameras?
Yes.
What else did you see on those cameras?
Well, there were several clips, but at some point, they came out of room 8. I believe Eric was going into room 8. I heard the different screaming but I just saw the commotion going in and out of the room with Eric.
May I approach?
May approach.
Your Honor, I am approaching with what has been pre-marked as State's Exhibit E 1 through 3.
Okay.
The state seeks to admit this into evidence.
Any objection?
No objection.
State's Exhibit 1 through E, 1 through 3 will be accepted evidence. You may publish whenever you're ready.
Thank you, Your Honor.
God! Are you kidding me? Shut the door! Shut the door! Shut the door! Shut the door! Okay! Oh God! You're just sitting there. Oh God! Are you kidding me? Sitting there right there. Oh God! Oh God! Oh God!
Is what we saw on those videos, does that truly and accurately reflect what you saw in those videos?
Yes,
Did you go out to the Lagoon Motel?
I did.
Were you there when law enforcement arrived on scene?
They had already arrived by the time I got there. I got there after the fact.
What did you do when you arrived on scene?
Just walked around trying to see what was going on with the situation. And then I just stood back and let the law enforcement handle everything. I stayed until everyone was gone and then went into the room, looked at it, locked everything up. And one of the deputies stayed with me the whole time. And I locked everything up and left, probably 2 hours later.
What was the condition of the room where you found it?
It was trashed. I mean, it was just trashed. Everything was everywhere.
Did you clean the room or search the room that night?
I did the next morning.
You did the next morning. And when you searched the room the next morning, did you find anything unusual?
Well, besides everything being trashed, there was a pillow that had been stuck behind the refrigerator, with, I'm assuming, bloodstains all over it.
Did you find any alcohol in the room?
There were empty alcohol bottles.
Your Honor, may I approach?
May approach.
I'm approaching with what has been marked, pre-marked as State's Exhibit F. The state would seek to have Exhibit F admitted into evidence as the picture of the pillow and pillowcase.
Any objection?
No objection.
State's Exhibit F to be accepted, that's F, will be accepted into evidence. You may publish whenever you're ready.
Thank you, Your Honor. Do you recognize this? What is it?
Is the pillow and pillowcase from behind the refrigerator.
And is this in the same condition that you found it?
Oh, yes.
Okay. Were you the one that took this picture?
Yes.
In those videos, the third one that we watched, was that Mr. Stoll?
Yes.
And you know Mr. Stoll?
Yes.
And what was he doing?
In the video,
Yes, ma'am.
I'm assuming was trying to break them up, because what I saw was him pushing her back in the room, and then it looked like Eric was going in there to break it up. But that was just my visual.
No further questions, Your Honor.
Mr. Meredith?
Ms. Dean, I'm Matt Meredith. We met back in September when I took your deposition. Now, mostly you do weekly rentals?
Yes, sir.
And Mr. Stoll, he stayed there quite a while.
Yes.
He was a longer tenant than just that week.
Well, when we do weekly, they pay weekly, but most of our people are there for longer than a week.
And so you knew him by sight and could tell him on the video, right?
Yes. Yes.
And you were watching these videos in real time, right?
Yes.
In the second clip, because it's in the background, I think Mr. White showed that was Eric that was standing out there kind of listening and seeing what happened.
From from that distance, yes, I'm assuming it was Eric from that far. Yeah, I mean, I know it was Eric on the last one up close.
And then the last one, he actually separates Mr. Worley and Ms. Demang, right?
Yes.
Okay. So he actually pushes Mr. Worley back into the room.
That's what it looked like. I mean,
and Ms. Demang's able to be out and Not in the room, not kept in the room.
That's what it looked like.
And the video surveillance, obviously you don't have video inside the room.
No, I do not.
So other than hearing yelling and screaming, you have no idea what happened in the room, who hit first, any of that.
Correct.
No further questions.
Redirect.
Briefly, Your Honor. You observed that third video,
Yes.
and you had encountered Connie and Anthony prior to that night?
Yes.
Okay. And you said earlier that you saw him pushing, or you saw him pushing her into the room?
On the video, yes.
On the video, right. And was she trying to get away from him?
It looked like it to me.
You know where your cameras are set up around the hotel, right?
Yes.
About how far is this camera from the hotel room?
This room is in the middle. So it's somewhere probably 35, 40 feet from the camera.
Okay. And what material are your walls made out of?
Concrete.
Concrete. And you could clearly hear what was going on the camera?
Yes.
From that far away?
Yes.
All right. And those screams, were those a woman's screams?
It sounded like a woman to me.
No further questions, Your Honor.
Any other questions? Can the witness be excused?
Yes, Your Honor.
No objection. Ma'am, you may go about your day.
Thank you.
White, you may call your next witness.
At this time, the state rests.
All right, ladies and gentlemen, we're going to take another short break. We'll start back around 11:15. If all of you looked at the last evidence, all right. If you'll leave your notepads in the courtroom, do not discuss the case among yourselves or with anyone. I'm going to ask everyone else to stay in the courtroom until the jurors have left. Don't check your media sources or use your electronic devices to find out any more about the case than you know right now. All right, everyone have a seat. Mr. Meredith.
Yeah, at this time, the state having rested and the court considering the evidence in light most favorable to the state, they have failed to prove a prima facie case as to all four counts. As to count one, aggravated battery, they have failed to prove as to the second element that in committing the battery, Mr. Worley intentionally or knowingly caused great bodily harm to her. Initially, I would argue that they have not proved that there was an intentional causing of the great bodily harm. Second, that they have not proven great bodily harm. Great bodily harm includes means great is distinguished from slight, trivial, minor, or moderate. It does not include mere bruises. They have produced evidence of a bruise on her face. There's been some testimony that she may have had some blood matting in her hair, but they have not produced any evidence showing any additional laceration. Further, the only evidence of any broken bones was Ms. Demang, and it's been backed up with no medical evidence. I think in the light most favorable to the state, it can only proceed as the lesser included felony battery. If we believe that there was great bodily harm, but that it was not intentional, I argue that it can only go forward as a battery. In count two, battery by strangulation, domestic violence. I don't think I can argue that this was not a domestic relationship, but they have not proved that he knowingly and intentionally impeded the normal breathing of Ms. Demang by applying pressure on the throat or neck or by blocking her nose or mouth. She was able to gasp. She was able to continue yelling. So there's not been approving of element one or element two, that there's a great risk of great bodily harm. As to count three, the aggravated assault, Ms. Demang's testimony was that she didn't remember a whole lot of it. She did testify today that he had the gun out and was waving it around, and then he pointed it at her. On cross-examination, Deputy Patterson admitted that she told him that he never pointed the gun at her. The gun was not found on him. It was in the pillowcase where Ms. Demang said it had been. And so if he threatened her, it only rises to misdemeanor assault. As to the false imprisonment, there's been no evidence that he kept her in the room, secreted her away, or tried to keep her there. She was able to get to the door. When she opens the door, they fall back in, and she immediately leaves. He has his arm around her waist, but Mr. Stoll is able to get her out. So there's been no credible evidence as to the false imprisonment.
Mr. White, what I'm most concerned with, I'm not concerned with counts 2 through 4, aggravated battery, and just if you refresh my memory, I believe that the alleged victim testified that she had a broken occipital bone.
Yes, sir, and a broken nose.
And a broken nose. Okay. All right. That's basically what, if you want to respond, you can respond as to that.
Your Honor, the jury instruction does mention that mere bruising is not enough to have, the mere bruising is not enough to prove great bodily harm. However, a broken bone would qualify as great bodily harm, and the victim is able to testify about the extent of her own injuries.
I'm going to deny the motion for judgment of acquittal. I believe that basically most of the defendant's arguments go to the weight of the evidence and not what the state's what I'm going to consider at this time. So I'm going to allow it to go to the jury. Mr. Meredith, are you anticipating on calling any witnesses?
I don't believe so. I've had a chance on a number of occasions, including I believe a couple times today at council table, to ask Mr. Worley. He knows my advice, but I would ask him if he intends to testify. The judge is going to ask you some.
Yeah, I'll go ahead. Mr. Ward, I asked the clerk to swear you in. I'm going to just ask you a few questions about your decision, okay?
Raise your right hand, please. Other hand. You do solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth to help you God.
All right, Mr. Worley, state your name, please.
Anthony Worley.
Mr. Worley, Mr. Meredith has indicated that you made a decision not to testify in this case. Is that correct? You understand you have a right to remain silent?
Yes.
You have a right to testify. Do you understand that?
Yes.
That the only person who can make that decision is you. That is perfectly permissible and advisable to listen to your attorney, but ultimately the decision is yours. Do you understand that?
Yes.
Is anybody preventing you from testifying today?
No.
Are you under the influence of any drugs or alcohol this morning which would impair your ability to make that decision?
No, sir.
Do you understand if you decided to testify that you couldn't just answer Mr. Meredith's questions, that you'd have to answer Mr. White's questions also? You understand that? You understand that up until Mr. Meredith rests your case and we begin closing arguments, that you can change your mind?
Yeah.
Okay. Is everyone satisfied with those questions and answers? Mr. Meredith?
Tony, we talked about the pros and cons of the testimony, what the pros were that I thought, and the cons.
Mm-hmm.
Are you satisfied with that?
Yes.
Okay. So you're going to rest when the jurors come back in.
Yes, sir.
Do you want to go ahead and are y'all prepared to go ahead and do closings at this time? You want to take a lunch break, come back early?
My suggestion would be, rest, have a brief charge conference, make sure that we're all the same so that Mr. White can,
Make the changes?
take the change out that he needs to, come back, go in closings and maybe come back at 12:30. Should have it to the jury by 1.
Okay. Mr. White, you okay with that?
So having lunch,
Yeah, we'll do a charge conference right now. And then you can make the changes and then I'll bring the jurors back in, excuse them for lunch until 12:30 and we'll go into, closing arguments and final instructions.
okay, that's fine, Your Honor.
You good with that?
Yes, Your Honor.
All right, let's go ahead and do the charge conference. I have the instructions that Mr. White has provided to the court.
Your Honor, Mr. Meredith has indicated to me that there may be an issue with the verdict form not printing the four-person line correctly. On my copy, it printed correctly.
I've got, it looks like it, what happened?
But 4-person is on page 2 when I printed.
Oh, yeah, the verdict form I've got is 4 persons on the same page.
Okay.
That is, so say we all dated and, signed, I mean, and the 4-person. So that's the only problem you had if it was on 2 pages?
On the verdict form.
Yeah, I'm looking at the verdict form, yeah. So, okay, good, okay. All right, statement of the charge, any issues with that?
Yes, sir.
Aggravated battery, any issues with that?
Yes, sir.
Lesser,
Yes, sir.
felony battery and battery,
No, sir.
domestic violence battery by strangulation,
Yes, correct.
lesser included crimes, battery by strangulation,
No objection.
battery.
No objection.
Hold on just a second with me. Okay. And battery, aggravated assault,
No objection.
and then lesser's improper exhibition of a firearm
No objection.
and simple assault. False imprisonment
No objection.
and no lessers.
That's correct.
All right, reasonable doubt, plea of not guilty, reasonable doubt and burden of proof. Any issues with that?
No, sir.
Weighing the evidence, we'll need to take some of these out. 7, I mean, we'll at least, take it, leave all of them in.
Yes,
You've already done that, okay.
We've gone over them.
I'll shut up. You've already done that, so
Yes, sir.
that's
It's-
fine.
The last paragraph on that page is the defendant becoming a witness.
Yeah, that'll come out.
Would you like an updated page or would you just want?
No, yeah, what you'll do, if whatever changes, if there's, you'll need to do an updated.
Okay.
All right, the lawyer's talking to a witness. Then the defendant not testifying.
And Judge, just for the record, as the court knows, I only want the first paragraph. Mr. White.
Has already done that. All right, very good. Defendant statements,
Yes, sir.
rules for deliberation,
Yes, sir.
cautionary instruction,
Yes, sir.
notes, verdict. And the verdict form I've got has the 4-person on the same page of the 5 counts, 4 counts. And then submitting the case to the jury. All right. So if you'll make those changes, I'm sorry, Mr. Meredith?
I don't know that this matters on the verdict. Talking about the verdict, the last paragraph on that is the same as single defendant, multiple accounts for information. So I think you're reading that twice. But I don't mind that.
So delete that from the verdict form or delete the single defendant multiple counts.
Yeah, I see. Yeah, just take that page out. I mean, take that paragraph out.
From the verdict form?
No, hold on. Yeah, let's take that last paragraph out on the verdict and then leave the single defendant multiple counts of information. You understand? See that?
Yes.
And then you'll just send that, are you gonna send that to the clerk?
Yes, sir.
Okay. All right. You wanna go ahead and bring the jurors in and break them for lunch?
Yes, sir.
And then we'll come back and we'll be ready to go at 12:30. Mr. Meredith, you may call your first witness.
All right, this time the defense will rest as well.
All right. All right. Everyone's present in the courtroom. Deputy Dexter, my understanding, you have a verdict?
Yes, sir.
Let's bring the jurors in. All right, see, Ms. Rodriguez, are you the foreperson?
Yes.
It's my understanding the jurors have reached a verdict, is that correct? If you'll hand the verdict form to Deputy Dexter. Madam Clerk, if you'll publish the verdict, please.
In the Circuit Court of the 14th Judicial Circuit in and for Bay County, Florida, State of Florida versus Anthony Wayne Worley, case number 24 CF 3355. Verdict. We, the jury, find as to defendant Anthony Wayne Worley as follows. Choose only one per count. Count 1. The defendant is guilty as charged of aggravated battery. Count 2. The defendant is guilty of domestic battery by strangulation. Count 3. The defendant is guilty of assault, a lesser included crime. Count 4. The defendant is guilty of false imprisonment. So say we all, dated this 9th day of January, 2026. Foreperson, Jennifer Rodriguez.
Madam Clerk, will you poll the jury, please?
Yes, Your Honor. Mr. Goff, is this your verdict?
Yes, ma'am.
Ms. Rodriguez, is this your verdict? Yes. Ms. Blaine, is this your verdict? Yes, ma'am. Mr. Johnson, is this your verdict?
Yes, ma'am.
Ms. Flusser, is this your verdict?
Yes.
And Ms. Gonzalez, is this your verdict?
Yes, ma'am.
Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. For hundreds of years, we have recognized that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you're at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. Ladies and gentlemen, thank you for your time, your consideration. Thank you for your service, because that's exactly what you provided today. This is what separates our country from a vast majority of the world. We have citizens that come in here and make these decisions. We don't have government officials. We don't have judges appointed by governors or presidents to do it. We have the citizens come in here. With that being said, that concludes your jury service. Make sure you have all your belongings. Leave your notepads here. We'll destroy your notes. The sheriff's office will escort you to the parking lot. I'm going to ask everyone else to remain in the courtroom until you're released by the sheriff's office. If you'll follow the bailiffs in the back.
Hey, gentlemen, we'll step this way, get the guards and deputies, that's what y'all are doing down the parking lot, running property out here in the juror lounge.
Everyone can have a seat. Are we prepared for sentencing today, or we need to order a pre-sentence investigation?
Mr. Worley, this is his first arrest ever, so there needs to be a pre-sentence investigation.
I'm gonna order a pre-sentence investigation. I'm gonna set this for January 23rd. I don't know if that I'll have, that's our motion day. I don't know that we'll have one by that time, but I'm gonna attempt to do it.
I'm just concerned about being able to get Mr. Worley on jail visits. I'm gonna be out there Monday afternoon, and then quite a few depositions with our division. And so I'm seeing BOP and arraignment people Thursday and Friday, and a Friday afternoon deposition. Mr. Stoll.
I have no objection not doing if there's more pressing things that need on. Pretty out there.
Let's set up them for February the 18th. That's our VOP and WOW docket in February. And that should give probation and parole sufficient time to complete the pre-sentence investigation. Mr. Worley's bond has already been revoked, so he'll remain at that time. So we can just go ahead and transport him back to the Bay County Jail. He'll remain there till sentencing.
Yes, sir.
All right. That'll conclude the trial.
Oh, yeah. It's like the end of the show and stuff, and yeah, I can talk, right? So, yeah, his bond is revoked. He's spending from now until February 18th in jail until he finds out what his sentence actually is, and then it's a pretty good guarantee he's probably still going to be spending time in jail after that, knowing Judge Clark and how his sentences go. I hope you found that as interesting as I found it. I saw it as it was happening earlier today, and it kept my attention. And I knew I had to show it, and I didn't want it to be like some of the other 2-hour cases I've had in the past where I just sat on them for weeks at a time and didn't show them. So you got it the day that it happened. Probably didn't see it many other places because those things go poof as soon as they're over, I swear. Ladies and gentlemen, don't forget tomorrow morning, we're doing brunch, 11 a.m. Central Time, 12 p.m. Eastern Time, and I got lots of stuff. We're gonna be doing all types of stuff. I got Simpson, I got Webster, I got all types of stuff. I got so much stuff I don't even know what I have. I may have some Rossi, unless everybody revolts on Rossi and just doesn't want to see it. But it's Rossi. I love Rossi. Ladies and gentlemen, we'll see. You'll see their faces on the thumbnail after I've decided what I'm going to do and I get it all posted. For now, I'm just going to say I am your humble host for these here videos and your curator for this here court gallery. I am your humble Lone Wolf Usul. And for now, ladies and gentlemen, I am out. Have a great evening. Just say no to Ferris Bueller references.